The breaking news, Sandy. And we're going to be joined momentarily. Oh, actually, we got him. Lucas Weber is joining us from the Wisconsin Institute for Law and Liberty, representing the Institute for Reforming Government. Let's just bring him in. Lucas, good morning.
Hey, good morning, Steve. Good to be with you.
The breaking news is a lawsuit filed today against the Wisconsin Secretary of State, Sarah Godlewski, seeking information. And this goes to the heart of open records. And I've said this over and over again. When we, the public, make requests about open records, we do it for a reason. We want to shed lights on what our government representatives, our agencies are doing. Explain the lawsuits. Where is this going?
Yeah, so back in March, you'll recall longtime Secretary of State Doug LaFollette resigned his position. And then that same day, Governor Evers appointed the current Secretary of State, Sarah Godlewski, to her position. So that same day again, our clients, the Institute for Reforming Government, submitted a public records request seeking information, communications about between various public officials, trying to figure out if, just doing a little oversight on what happened with that appointment. After months of follow-ups and trying to get an answer from them and being largely ignored, this lawsuit is an attempt to finally get those records once and for all.
Legally, by statute, by state law, what is she required to do?
Like all public officials, she's required to turn over the records as soon as practicable and without delay.
So what does that mean to the layman out there? Because I'm not a lawyer and Sandy isn't either. What does that mean? Like, is that when you get around to it, or is that in a timely manner?
Yeah, so the Attorney General has essentially said it depends on the request you make. In most cases, overwhelming majority of cases, a simple request, 10 business days is plenty of time for a public official to search their files and turn over those communications. In some longer cases, if you make a very complex requirement, it requires a lot of searching, it can take longer. The reason the statute itself doesn't set a specific deadline and say, within 5 days you have to turn it over is because it wants the court to take into account the request that was made and the amount of resources that would go into finding those records. In this particular suit, the request that was made is a simple one. It was just for communications between the governor and the former Secretary of State and the governor and the new Secretary of State and some staff. Very easy to search, very easy to turn those over. Shouldn't have taken much, but here we are almost 6 months after that request was made, and we haven't seen those records yet.
Is the implication here is that we're trying to find out what communication happened between Sarah Godlewski, the former Secretary of State, and the governor, just to see what was happening behind the scenes. That's the implication here, right?
Exactly, yeah. The idea is just to conduct a little oversight and find out exactly, what communications were happening, when did people know, and what did they know. It's pretty basic, just, keeping an eye on government behind the scenes. And as you mentioned, it's the public's right to know.
How often did these requests come through? Like, is it possible that they're flooded with requests because there's a demand for transparency in government?
Certainly, I don't know how many requests they receive or any government official receives. I can tell you that back in May, about 2 months after our client sent the initial request, the Secretary of State's office responded and said they were gathering the records and would be in touch soon. And that was, 2 months ago, more than 2 months ago. So, I think even if public officials receive a number of requests, the law says this is to be a priority, and it's to be a priority because the public has a right to know. These are the people's records. Our democracy works because people have ready access to conduct oversight on their government, and that's why this issue is so important.
Should the legislature in the future look at maybe putting time limits on some of these responses?
It's certainly something they could look at. I think we saw with a Supreme Court case from last year, there are some needs potentially to update the public records law. It was written at a time before electronic records existed. I think there are things the legislature could do to modernize the law and ensure that the public has ready access to these records in the kind of modern era.
It would be interesting to know what the turnaround rate was when Doug LaFollette was in this position, if there's a comparison to be made there. But there certainly is an argument to be made. This is the Secretary of State's, the old saying, you have one job, making sure that records are available for public inspection whenever required or requested.
Exactly.
Lucas Weber joining us from the Wisconsin Institute for Law and Liberty. Thanks for shedding some light on this. Hopefully we'll see some results, some records that'll be produced by the Secretary of State. Thanks for taking the time.
Thank you for having me.